Hi, Attorney Steve Vondran, and welcome back to Commission College, where sometimes you have to slug it out on the streets for your commission. This episode, we are talking about dual agency, double ending, the double popper, representing two clients in a transaction. So now this is a serious, I'm joking because it's funny, but again, it's not so funny because you can actually make tons of money doing a dual agency, but you have to be very careful or you could get your pantsuit off, make no money, and find yourself in a lawsuit. So it's a really interesting concept here on Attorney Steve's Commission College. Let's go to the Attorney Steve Real Estate Whiteboard. All right, we are talking today dual agency, okay? The case we're going to be talking about today is Brown versus FSB Brokerage. Brown versus FSB Brokerage. You can find the case at 62 Cal. 4th, 766. If you don't know what that means, type that into Google. You'll probably find the case, by the way. 62 Cal. 4th, 766. We'll have another video on what case citation means and how you decipher that. But we're talking about Brown versus FSB Brokerage. Our statutes at play today, Civil Code Section 2719, excuse me, try that again, Civil Code 2079.14. 2079.14 and California Civil Code Section 2079.16. This is California law, people, that we're talking about. And I would say in general, this is the same thing you're going to be looking at for my Arizona clients, my Arizona brokers, when we're talking dual agency. It's the same, different laws, different cases, but it's the same principle, okay? So let's go look at this. Okay. Let's start with the statutes. Civil Code Section 2079.14 talks about your dual agency disclosure. A dual agency is when you're trying to represent two clients in a transaction. So here's your property, okay? And here's your buyer, here's your seller. In the middle, we have our dual agent, the double popper, okay? The dual agent right in here. Now, most times in a transaction, a seller will just have you represent the seller, you'll be the listing agent, or the buyer will have you represent them, you're the buyer's agent or the selling agent, okay? Now, in certain times, the opportunity will arise when a buyer won't be represented or a seller won't be represented, and you will be able to sort of facilitate and be that middle person on the deal and put together a deal where you represent both sides of the party. Now, some people may say to yourself, wow, that's got to be against the law. You can't represent both parties. Actually, in California, you can. It's an issue, but it's legal if you do it right, okay? And that's what this code section's about. So basically, you have your 2079.14. It says to present your disclosure, your dual agency disclosure form. Present it to your buyer or seller as early as practicable. Now, from my opinion, this is my general legal information, this is not legal advice, but in general you want to think about disclosing that the minute you know that you may be representing both parties, you're going to want to get that agency disclosure form into the hands, signed, written, full disclosure of the conflict that you're representing both sides. Why is it a conflict? Because in normal circumstances, you're trying to get the most you can. You're trying to get the lowest price for the buyer, and you're trying to get the highest price for the seller. In a dual agency, you can see how that's kind of messed up because the broker is really incentivized to get the biggest commission possible, and you want to try to get them a good price. You want to try to get them a good price, so there's this inherent conflict. So you want to give the disclosure, agency disclosure form, that Civil Code Section 2079.16, and you can look up this code section, 2079.16. It'll tell you the requirements of the code section, basically disclosing that form as early as possible for your listing agents. Disclose it prior to obtaining the listing. To your selling and your buyers, present it prior to presenting an offer to purchase, okay? So you can look up the code sections. Here's where you're going to find the basic rules. If you're curious, you're about to enter into dual agency, look up the rule. It's not going to kill you. In Brown versus FSB Brokerage, interesting case. This was, I believe it was a Beverly Hills or Hollywood property, one of the two. $2.6 million. Long story short, the seller believed that the agent was representing just the seller. Okay, and the agent said, no, I told you I was representing both parties. It was in an escrow instruction. You remember, it was in an escrow instruction. It was right in there. And I told you to. I told you orally that there was a double agency. You knew. But it wasn't disclosed in writing per the requirements of the code. So this created a case where the seller, who believed that the agent was representing just the seller, the allegations were that the buyer was told that the seller would accept less than he would actually accept. So the price ended up going from like 2.6 down to 2.4. There's this money that the seller believed was lost. At any rate, the seller concluded the transaction and then came back and sued the brokerage, okay, and the agents. So that's what the case was about. The case was there an adequate disclosure? The case dealt with the issue of whether or not the seller had to seek a remedy of rescission of the transaction, or whether the seller could seek money damages. And the court did not require that. In this case, I believe, was on a motion for summary judgment, and it was a reversal of the motion for summary judgment for you legal buffs. But essentially, it talked about an agent risks their commission if they're an undisclosed dual agency. The remedy does not have to be the seller seeking rescission of the deal, meaning to unwind or cancel the deal. That was not required. And if the seller could prove damages, if the seller could prove that the buyer was not working in his best interest and it was an undisclosed dual agency and he lost money as a result, the seller states a cause of action against the brokerage. Now, I want you to realize, some people don't realize a dual agency, sometimes they think it's, you know, just one agent. If you have one brokerage, I have DA equals brokerage. If you have a brokerage, and the brokerage here represents, you have one agent for the brokerage that represents the buyer and one agent for the brokerage that represents the seller. They're two different agents, but it's the same brokerage. You still have a dual agency relationship. So you got to bear that in mind, where your firm, if you're the broker, where your brokerage has two agents that are representing a seller and a buyer, you need to be very careful or your commission is at risk, and you'll end up over here putting these gloves on saying, Attorney Steve, please help me. What do I do? I want to keep my commission. So my tips, my general tips when doing dual agency, 3 tips, Attorney Steve's top 3. 1, full written disclosure as soon as possible. Full written disclosure as soon as possible. Written means not oral. Telling somebody isn't enough. Putting it in escrow instructions isn't enough. Giving them a signed disclosure at the end of the deal, not enough. Up front, as soon as possible, set forth all facts, and I would put together all potential adverse consequences of the representation, just like an attorney does. If you're entering into a dual agency and you think you've got a chance to make a nice commission, you may want to seek legal counsel. You may want to give us a call to discuss. Tip number 2, make sure you have the knowledge and consent of both parties. Knowledge and consent of both parties. Get it in writing. Don't leave anything to chance. Make sure everybody is on full notice of what's going on, what your role is, who you're representing. And tip number 3, make sure above all that, not above all, these are super important, make sure you're adhering to your fiduciary duties. You know those fiduciary duties: duty of care and reasonable skill, duty of integrity, honesty and fair dealing, no secret profits, right? No secret dealings, loyalty, being, now this is where it gets a little tricky, right? In some senses, you become a facilitator as opposed to an advocate. No secret profits. Duty of full disclosure of all material facts that would affect the decision making or the value of the property or the decision making of any of the principals, okay? Full disclosure and confidentiality. Do not be telling the other side secrets about the other to try to get him up or him down, this or that. No secrets. That's why it's tricky. So I would advise you, if you're doing a dual agency in California or Arizona, for my Arizona brokers, don't leave it to chance. Get an attorney involved. have somebody on your side helping to make sure that you're balancing the interest, getting the disclosures that you need. And of course, if you messed up and you're watching this video because you got sued or you found yourself in a lawsuit or a real estate ethics violation, give us a call. We can help you represent your interests. And that's, my friends, a quick, dirty Attorney Steve overview of dual agency, the double popper. Okay? So do it right, you can profit. Do it wrong, and you'll find yourself in a potential problem. As the court said in Brown versus FSB, the agent who commits undisclosed dual agency risks losing their compensation, i.e. having their commissions disgorged. Okay? Attorney Steve, best of luck out there in the real estate world. Give it your best. If you have any issues, you need a real estate business lawyer, give us a call, 877-276-5084, or find me on the web at attorneysteve.net. We'll see you again. Thank you.